Hi, I'm Debbie Moraes. Once again, this is Legal Matters, the program that's been designed to address the critical, sometimes contentious issues that are facing businesses and consumers today. As we say, it's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. As always, we want to thank from the Bazar Grassel Law Firm in East Providence, David Bazar. We wish Jackie were with us.
We do.
Next time. We thank you for providing your insights, as you always do. And today, we figured it would be a very timely and, yes, sometimes contentious topic. Bad weather and accidents, snow and ice storms, especially snow that's accumulating on walkways, never mind your personal driveway, parking lots. All of these things can lead to slip and falls, hazardous accidents, and behind every serious accident or not so serious accident, there lies a personal injury lawsuit waiting to happen. So what is it that you need to know? There are things called premises liability that hopefully David will discuss. And when there's a car accident in this terrible weather, who's at fault? And what about your neighbor's sledding or your sledding in your neighbor's yard, and there's some sort of serious accident? You could actually have more trouble, or at least as much trouble as the injured person. So we have a lot of issues for David to address. Let's get started with the basic slips and falls. There's lots of snow happening. Who has to remove what and where?
So let's start with a business.
Okay.
So you have a business and people are expected to be at your business to patronize it, and you know they're going to be there. So as the business owner, you have a responsibility to make sure that the path in and out of the store is free and clear from snow and ice and other debris so that people won't get hurt. Now, does that mean in the height of a snowstorm you're responsible if someone walks in and falls even though you've done everything you can? Probably not, because you're only supposed to act with the reasonable due diligence of a shop owner given the nature. You're not an insurer, which means that you're responsible no matter what happens. But you do have to take reasonable steps to protect the safety of the people you've invited onto your property.
So in keeping in the spirit of what you're saying, there were actually some of those 24/7 stores that remained open, and in the height of a blizzard or when it's terribly treacherous, maybe they couldn't get out in front of it because it's just in the middle of a storm, and someone decides that they're going to go out and get their milk and butter at 3 in the morning or whatever. So if someone slips and falls then, are they less likely to be sued because they couldn't do anything then?
They may still be sued, because you can really sue sometimes for just about anything.
Yes.
But whether they'd be successful or not in suing you is a different story, and it would be much less likely that somebody could get a jury verdict against you for someone who came into the store at, say, 11 p.m. in the height of a snowstorm when there's a travel ban, and they are coming in while the snow is snowing at 2 to 3 inches an hour, and you've put salt and you've shoveled and you've done everything you can, yet they fall anyway. What more could you have done? And the jury might also look at that, if it ever went that far, and say, what more could this store owner have done to protect the public? You did everything, then that's all that can be expected of you.
So you might get a suit for covering the medical expenses, but nothing punitive, really?
Well,
is that how that would go?
As we've talked before, everybody who's in business, we've talked about forming corporations and having limited liability companies and all those things to shelter you from personal liability. But no matter what form it takes, we've always talked about having insurance. And again, insurance is going to step into your shoes and only be as responsible as you are. Some insurance policies, however, do provide for medical payments for people who are hurt on your property, regardless of who's at fault.
So, okay, and if you're not a business, say you're a property owner or you're a renter, who has what responsibilities for clearing snow then?
Okay, so we're still in a commercial setting, business?
Of sorts,
okay.
Sure.
So in that setting, there's a couple of different things. As a lawyer who does personal injury cases, if I find that there's been some negligence, I'm going to sue everybody associated with that negligence. So if you're renting a piece of property for your business to operate out of, I'm going to sue you as the business owner and operator for not having the premises clean and clear of any debris or whatever caused the injury. As the owner of the property, I may sue you because the onus may fall on you. What happens oftentimes is there's a lease between the business owner and the property owner, which will lay out who's responsible for what. If it's maintenance of the property, it might be, for example, the property owner. But if it's removal of snow and ice, they may have put that back on the business owner. In either event, as far as my client is concerned, I would say you're both liable because both of you owe a duty to my client to make sure the pathway is free and clear and safe for the person to travel.
Okay, and that's in the commercial sense that you might go after. How about if you are a landlord of a rental property for a resident?
Okay.
Who is responsible for what, and how do you know?
So
When?
again, in a residential setting, there can be a similar situation with a lease and having the responsibility laid out between the resident and the tenant, I should say, and the landlord. As a person, a third party who gets injured there, I'm going to sue the landlord, at least the landlord, if not both, but primarily the landlord because they're the property owner. They're most likely the one with insurance coverage, and they're most likely the one with the deep pocket that I could recover from. Now, as between the tenant and the landlord, that really will often depend on a lease if there is one. So on a case-by-case basis, I couldn't sit here and tell you it's always the landlord that's responsible for the snow and ice removal or the tenant, or what other arrangements they have. Sometimes in bigger buildings where there are multiple tenants, there's a property manager that could be responsible for doing that. Sometimes there's someone who's in the building who says, reduce my rent a little bit and I'll be responsible for doing those things. So there's multiple possibilities of what might be the right answer. But certainly a landlord always bears some responsibility.
But you're saying prophylactically someone should make sure that they check that lease, whether they're responsible or whether their landlord ultimately is going to be responsible.
Right,
That has to be stated clearly.
Yeah, that's something that you probably would have talked to. If the landlord is shifting the responsibility to you as the tenant, it's a single-family house, you're renting the house from the landlord, then right in the lease or right up front as the agreement is entered into, if I'm the landlord, whatever it is, I want it in writing.
And if the devil's in the details, so if I'm the landlord and I have the snow removed, but then it ices up because it was very cold last night, can it ever be just the renter's responsibility to throw the rock salt out or whatever their kitty litter is to make sure that it's safe after that?
Oftentimes, that's why they'll enter into an agreement so that the person who's renting the property will have some responsibility because they're there, the tenant. The landlord's not usually there, they live somewhere else. Sometimes they live there in multi-family situation, but again, depending on the situation, I'd say the landlord bears ultimate responsibility. But if you're a tenant and by either history, practice, or lease, you've got some responsibility, you have to also use your common sense. If you know the landlord's not there, he's been there, he or she cleared the walkway, plowed the driveway, but it's continued to snow, you have to bear some responsibility for taking care of yourself as you leave, either by putting salt on, as you say, or walking carefully, or if it's still in the height of the storm, you're assuming the risk by going out in the first place.
Which is a good point, too. Okay, so suppose you just happen to be a resident, you own property in Providence or some other major city. I assume that it changes, the laws are written specifically from municipality to municipality, but it used to be, gee, wouldn't it be nice if you just took care of your and your neighbor's common way, but right now it's the law that you clean out your walkway, not just your driveway, and where does that cut these days?
So there's a number of different ordinances, cities and towns, as you say. Sometimes they vary slightly from city to town, but maintaining your sidewalk so that it's passable for people, even though the sidewalk may be in some cities and towns owned by the city or town, the ordinances say the abutting resident is required to remove snow and ice. There's also requirements that you not remove the snow and ice from your driveway and the sidewalk and put it in the street. They plow the street. They don't want you then plowing your driveway into the street.
And what happens if you happen to be infirm and or elderly? Apparently that was even in the news when we talk about the timely topics here. If you are unable to take care of the property because you can't go out and shovel if you're 91 years old, but the city, apparently you can call the city and they can take care of it, or how does that happen? I know there are volunteer organizations. Suppose it's not taken care of and something happens. Who's at fault? What happens?
Well, again, based on the ordinance, the owner of the property is responsible. Now, there's a reason why they can't What we often do, what I did, I remember, so you won't believe that I go back this far, but in the blizzard of '78.
You were two.
No, I was old enough. I should have been back at college. I still had school that day after the storm, but I couldn't because of the driving ban. Living in Providence, couldn't get back to Connecticut. But the long and short is we would go to people's houses, and if someone couldn't do it, we would do it. Hopefully they'd maybe even pay us a little bit for doing it back then, but if they couldn't, we did. So I've always been a big believer of if you have a neighbor who you know can't help your neighbor, but if you're talking about legal issues and legal matters and who's ultimately responsible, even if you're infirm, you could hire somebody to do it. The city and town may help you, but they're not bearing the responsibility. They're not saying, well, if we don't get there in time, you're off the hook. So you still bear the legal responsibility for getting it done one way or another.
And what happens if you just happen to be in Florida and an unexpected blizzard happens? Ordinarily, you would take care of it yourself. This time you can't. You're responsible nevertheless?
Pick up the phone, call somebody. If you have somebody who's going to plow the driveway for you, make sure they clear the sidewalk too. There are ways to communicate to make sure that you live up to your responsibilities.
Is 24 hours considered to be a reasonable time within which to remove that snow and ice? Maybe that 24 hours is in the middle of 11 o'clock at night, and I'm not happy about that. I might get out and do it earlier, but is there a grace period?
Yeah, well, again, during the height of the storm, obviously no one's expected to get out and clear the sidewalk while 2 to 3 inches or more are coming down an hour. But there's, again, within reason, and some of these cities and towns have right in the ordinance a time frame that you must clear it off within 24 hours or whatever time frame they might put into that one. But I think you got to go back to what's reasonable in the situation. If you're talking about feet of snow instead of inches of snow, there might be some more leeway to work on that, because I don't think anyone's expected to go out, do it all at once, and have a heart attack. You have to be reasonable as how you do this stuff.
And what about your own personal responsibility for being careful? Surely, if it's icy, you might want to stay in, but you can't, and now you have to walk down a neighbor's path or walk down the street path. Could it ever be my fault that I slipped and fell? I was wearing stilettos in the middle of a snowstorm.
Sure.
Does that mean that the owner of the property gets a pass under those circumstances if I'm not careful?
Not necessarily.
Okay.
In Rhode Island, we have comparative negligence, which means that a jury can look at both the negligence on part of the landowner or the person who is responsible for maintaining the property, and the negligence of the defendant in how they approach the issue. So if, by way of example, you didn't do anything to clear snow and ice from the area where you knew people would be walking, and then someone comes along running unnecessarily with high heels on, as you said, the jury can say, well, the landowner has some responsibility for this. They contributed 50% to the reason that there was an accident, and the person running contributed 50%. So you would only recover half of your damages in that situation. And I'm just making those numbers up. The jury can find whatever it assesses liability at on both the plaintiff's actions and the defendant's actions.
Okay. And one other issue, when it comes to neighbors, your neighbor goes to deliver you a hot cup of soup and slips and falls. You don't really want to sue your neighbor because they're trying to do something nice, but should they not sue, or is it just a matter of, don't worry about it, my homeowner's insurance will take care of it and we don't have to worry about getting into a litigious, lengthy battle?
Yeah.
How do you address that?
So if somebody is hurt because of somebody else's negligence, most times there is insurance to cover that. That's why you have insurance. So in a car accident situation, if your neighbor's driving next to you and you go through a red light and the neighbor gets hurt, the neighbor can sue you. Now, you may not be comfortable with that, but you have car insurance that's going to cover you for that. If your neighbor is legitimately hurt because you did something wrong at your house that caused them to be hurt, your homeowner's insurance will cover that situation as well. And again, there can be a little bit of bad blood because of this, but you have responsibilities. That's why you have insurance, and hopefully you understand that you're helping your neighbor become whole again because of something that happened, that was your responsibility.
Good to know. And of late, people are talking about the wonders of the snowplow. Those companies, too, have great liability, both for them, I guess, when they come to do work in your property. If they're hurt, who's to blame? They're doing a service. Should they be able to sue you when they're doing your driveway and they slipped and fell on the way out the door or something?
Well, if they're there to remove the snow,
Yes.
and they fall on the snow,
Yes.
then I don't think you've really done anything to create a liability to them that you would be responsible for. You weren't negligent. If they came to remove snow and the door of your house fell off
Different
its
story.
hinges and hit them in the head,
Different story.
then you're liable because you did something wrong.
Okay, and what about the employee of the snow removal company? Is there something about paperwork that absolves that business owner? So maybe somebody gets hurt on the job, on their watch, while you're working for a snow removal company. Does that employee of that snow removal company get to sue while he's hurt on that said job of removing snow?
Well, it's workers' comp,
Okay.
first and foremost. And as far as an employee suing the homeowner, if the homeowner, again, didn't do anything wrong, there's nothing to sue them for. If they did do something wrong, then you could have what we call a third-party case, which is for the negligence of someone other than your employer or co-employee. So you can have both your workers' compensation case and that third-party case if there's a factual basis for proving negligence against the homeowner for something that they did other than having snow on their property.
Good to know, because someone actually said that they didn't want to bring a snow removal company in because they were afraid that someone might get hurt while they were doing the job. So at least we have that covered. Is there ever, during the snow and ice storm, is there ever a reason or excuse for an automobile accident?
Okay, so I've had these cases.
I'll bet.
Yeah, so I had a case once where a woman was driving up a steep hill, or down the steep hill, I don't remember exactly which, but in any event, it was ice that you couldn't really even see. And her car lost control and went down to the bottom of the street and hit a pole. And while she was standing there, another car came down, lost control on the ice, and hit her car, and she was injured as a result of that. And I didn't want to take the case because it was a situation where, almost like we would call it an act of God. There was nothing anyone could do really to guard against that situation because you couldn't see the ice. My client had the same unfortunate experience as the person behind them, and if they had seen what happened and then went down, then I would have taken the case because then they would have been negligent for going down after they already had seen that there was a problem and that you couldn't control your car. But having her already go down, the other person didn't see her until he came over the top of the hill and then started down and then had no chance to stop. Sometimes there is something that's just an accident. Nobody did anything wrong. They couldn't have done anything differently. That's not the usual case.
But what happens in that case? There's no suit, and you just take care of the medical issues?
You have, there's no one to sue.
Got it. Okay.
But that's not usually the case. Usually the case is someone's driving too fast in snow and ice. You stop, they can't stop because they're going too fast. It doesn't matter that there's snow and ice in that conditions because they're aware of the snow and ice and they're driving too quickly for the conditions that cause them to lose control and then hit you. Now that is negligence and that's something you can sue and recover for.
If you are driving the speed limit, however, the overarching issue is that it's bad weather, you should be driving a little slower. Is there
Right.
anything written in the books, 5 miles less, 10 miles less, and if you don't, then you're in trouble?
There is a statute that says you have to drive, and you can actually get a ticket for driving too quickly for the conditions. And as a municipal court judge, I've had people come in and they said, look, I got a ticket. I was doing 25 and a 25, and they gave me a ticket for driving at an unreasonable speed based upon the conditions. And I said, because 25 is not reasonable when there was all this snow and ice and you ended up hitting the telephone pole at the end of the street instead of being able to turn. So conditions requiring reduced speed doesn't mean the speed limit.
Got it. And so therefore people can raise suit.
Yeah.
Okay, what happens in these bizarre situations, such as in a snow and ice, when there's a third party or a multi-car accident? Someone didn't stop, rear-end someone, who then ends up rear-ending someone else or hitting someone or something else. How do those suits play out? How do you deal with them? What should you do if you happen to be one of those parties?
So multi-party accidents happen often. We deal with those all the time. So you're stopped at a red light and you get hit from behind, and then there, lo and behold, 2 or 3 others behind you. One of the first questions you try to figure out is, was there more than one impact? So in other words, did the car behind you stop and the car behind that car stop, and then it was the 4th car in that hit everybody and caused the accident? And if that's the case, then all the liability rests on the 4th car, and everyone who's injured would look back to that owner or driver for coverage and have their liability, their damages covered by that accident.
And it doesn't matter that it happened to be a black ice. How do you legislate that? How do you control that? How do you deal with that?
I gave you the first black ice incident, so to speak.
Yes.
But like I said, if you know it's snowing out and you're driving in those conditions and 3 cars were able to stop at the light before you got there and you were driving too fast for the conditions, then you're responsible.
Okay.
If you're talking about this car skid, that car skid, and the next car skid, and they all skidded, and you've seen these things sometimes on TV on highways where cars are all skidding out of control, and nobody knew it was there at the time they approached it until the car way back should have seen it, then there might not be liability.
Okay, okay. When these kinds of things happen, I understand that you'd want to document whatever you can. You always say get out, take photos, assuming that you can, that you're not terribly hurt. Right. Take the cell phone out, take a picture of what happened. I think that it makes sense you might want to see if there are witnesses, but when there's snow and bad weather, does that change the scenario of what you're responsible to gather before someone comes to see a lawyer and present a case or see if there is a case?
Well, it's always better if you have documentation, photographic or otherwise, as to what the conditions were. So if you're likely to be sued in a situation and you can show that, well, look, there was no snow and ice except for this one patch of ice that nobody could see, and 3 people hit it and all had the same miserable experience, then, that's helpful. Or get the statements or the names of the other people. Obviously, if you're injured and you were hurt by somebody else who hit something and you can't get the picture because you're in the ambulance, we understand that. We'll go out, we'll get names of witnesses and interview people and do what we can do to gather up that evidence for you.
Okay, good to know. And then, not car accidents, but children and sledding accidents. Kids like to go out sledding, I understand that. So if you happen to go sledding in your neighbor's yard and the child goes out of control on the sled or the coaster or whatever and hits the picnic table.
Okay.
Is that a suit? What's the trouble? What
All right.
happens?
So how about this? The very first trial I ever tried in front of a jury, and again, I won't tell you how long ago it was, but it was 1983. Okay. So, young girl goes sledding on her neighbor's yard in a rural area of Rhode Island, and they're going all day long, having a great time, kids laughing, bunch of kids there. The neighbor's yard actually happened to also be somewhat of a junkyard dump. And so she's sledding down in a new area, and there's an engine block sticking out of the snow. And so she turns to avoid the engine block, the sled clips it, she falls off the sled, and she breaks her leg. So the defense of that case, the insurance company's attorney said, there's no liability, they didn't do anything wrong, the kids were over there, they were trespassers almost. Well, they weren't trespassers, they were invited over, other kids were there, they knew the kids were there. Rhode Island has actually gone around the mulberry bush a little bit on trespass law, but that's a whole nother story about kids being hurt where there are what we call attractive nuisances, and there's a case called Mario Renzi where they changed the law and then they changed it again and then changed it back. But just in this particular case, we'll talk about it. So the little girl breaks her leg, she goes home, they're having dinner, she stays on the couch, goes to the hospital the next day, they x-rayed, it's a broken leg. So they thought, they being the insurance company's attorney, that my case is going to get thrown out after I present the case because there's not enough evidence to prove negligence on behalf of the defendant. So they didn't make an offer. So we present our case, we go through the whole trial, And they move for what they call a directed verdict to throw it out. And the judge says, no, there's plenty of evidence to show that they knew the kids were there, that they knew that they were sledding all day long, and that there were hazards that they either didn't warn about or remove before the kids were sledding there. So they present their case, the case goes to the jury, they make us an offer. And it was a pretty good offer back in the day for a broken leg, and I said to my clients, we really should settle at this point. That's what we would have taken before trial. We got to the point where they're making the offer now, we should settle. We're done for the day. They went home. The mother and father came back the next day and said, you know, we talked it over, we talked to our friends, our neighbors, and everybody else, and we decided we've come this far, we may as well see the rest of the show. So I immediately actually had my office type up a letter telling them that I recommend they take the settlement. You never know what a jury's going to do, and a settled case is a good case. So I had them sign that. The jury goes out, they deliberate for a while, they come back in, and they find for the defendant. So my client turns to me and he says, how much does that mean we get? And I look at him and I said, that would be zero. And afterwards we spoke to the jury, the judge and the two lawyers, and just asked, thanked them for the thing, and wondered why they had come the way we did. And the judge was talking to the jury, and one of the jurors said, you know, what we were concerned about is if she had a broken leg from the sledding accident, why didn't she go to the hospital until the next day? And it's nothing that I had ever thought of, or the defense attorney had ever thought of, or the judge had ever thought of. And the point is, you never know what a jury's going to do. But the long answer to the short question is, can you be liable for people coming over your house and sledding and having an accident under the right circumstances? The answer is yes.
So that was a piece of motor, or whatever.
Right, the engine block to a motor.
Engine block. Someone else has a picnic table. Both of those things could be removed. Suppose it's a tree. You weren't going to cut down every
Right.
tree in your forest.
No.
So
And so, again, if that were the situation, probably no negligence in that case.
just a suit, and you'll take care of the medical
Well,
if you're the homeowner.
perhaps. And as a good lawyer, I might be able to find negligence if you have created a little racetrack there for sleds to go down, knowing the tree's there, and knowing you have young children. But if the children are doing it on their own and you weren't home, or you find out afterwards, maybe no negligence. And if you had created a place for them to sled and they went off on their own afterwards, probably no negligence.
Okay, and one other facet. Now they talk about, never mind, kids on bicycles with helmets. What about kids on sleds? If there was a head injury, could you come back and have some recourse and say, well, I'm sorry there was a head injury, but the child should have worn a helmet? Do you have a shared responsibility under that circumstance, or no?
Well, you would have to look at comparative negligence and determine whether or not it would have been reasonable or unreasonable for the child to have a helmet on sledding. Certainly, as you know, with bicycle laws and bicycles, helmets, have become more prevalent. I'm not sure how prevalent they are, although kids on snowboards and skis these days all wear helmets, so it might not be unreasonable. But it's really based on what's reasonable, and now we're talking about a child who is making the decision. You take the child and their negligence. If it's a parent who's made the decision, you have to look at a different situation.
That certainly does make a much more complex story, doesn't it? We thank you for tuning in. Please continue to stay tuned to the legal matters, as our discussion of legal matters will continue.